defended the statute.
Initially, yes, my lords. Initially, the government defends the
Initially
statute.
means throughout the proceedings
Yes.
before the High Court, they defend.
Throughout the High Court, my lords. And here
Para
the government.
68.
Yes, my lords. May I
Actually,
read,
you
my
can
lords?
see, actually, you can see para 67 because that's important.
Yes, my lords. I'll just read that, my lords. Para 67, page 65 at the bottom of the page, my lords. To provide education, my lords all have it. To provide education, more particularly for minors, that is children up to the age of 18 years, is a constitutional duty of the state. Under Article 21A, state is bound to provide compulsory and free education to children between the ages of 6 and 14, that is from classes 1 to 6. Further, it is the duty of the state to provide education which is secular in nature. It cannot discriminate and provide different type of education to children belonging to different religions. Any such action on part of the state would be violative of secularism, which is part of the basic structure of the Constitution of India. Such an action on the part of the state is not only unconstitutional, but also highly divisive of the society on religious lines. To maintain unity in the society is a primary duty of the state and all its authorities. Any policy of the state which is divisive of the state on religious lines is violative of constitutional principles. Where any legislative act of the state is violative of the basic structure of the Constitution, one of the core principles of which is secularism, it is bound to be struck down. Para 68. The defense taken by the respondents, including the state government and the Madrasa board, is that the state has sufficient power to frame laws with regard to education to be provided at school level, including traditional education. It is argued that in exercise of its powers under entry 25 of list 3 of schedule 7 of the Constitution of India, state has enacted the Madrasa Act. It is claimed that while having the power to legislate for education, it also has sufficient power to legislate on traditional education. And since religion is part of traditional education, therefore state government can legislate on the same also. Further, in case this court finds any provision of the Madrasa Act to be violative of the Constitution of India, it may only strike down such provisions and may save the remaining portions of the Act. The entire Act may not be struck down by this court. Further reliance is placed upon Articles 25 to 30 of the Constitution of India. The board and other respondents, while adopting arguments of the state, have further submitted that Articles 25 to 29 provide rights to propagate religion, and under Article 30, the rights of minorities to establish and administer their educational institution is specifically protected. They submit that state government has sufficient power to establish a board for religious education of a minority institution. Para 69.
70, 25, 29.
His reasoning. No, we don't have. May I continue, my lords? Para 69. No, page 74. No doubt the state has sufficient power to frame laws with regard to education to be provided at school level, both primary and thereafter up to intermediate. However, such education has to be secular in nature. The state has no power to create a board for religious education or to establish a board for school education only for a particular religion and philosophy associated with it. Any such action on part of the state violates the principles of secularism, which is in the letter and spirit of the Constitution of India. The same also violates Article 14 of the Constitution of India, which provides for equal treatment to every person by the state. Para 70. This is important, my lords. So far as Articles 25 to 29 of the Constitution are concerned, the same relates to the rights of citizens and not those of the states. It is the citizen of this country who have the right to profess and propagate their religion and its values. It is not mandatory for a citizen of this country to be secular by nature. He can have faith in his own religion or in every religion, or may not have faith in any religion. But the state cannot do so. The state has to remain secular. It must respect and treat all religions equally. The state cannot in any manner whatsoever discriminate between religions while performing its duties. Since providing education is one of the primary duties of the state, it is bound to remain secular while exercising its powers in the said field. It cannot provide for education of a particular religion, its instructions, prescriptions, and philosophies, or create separate education system for separate religions. Any such action on the part of the state would be violative of the principle of secularism.
Come straight to 83.
83, my lords.
83. So that's Article 21 and 21A. That's the finding.
Yes, my lords.
Read it.
May I just read that, my lords? Paragraph 83.
From the above
Discussion, it is clearly established that education under the Madrasa Act is certainly not equivalent to the education being imparted to the students of other regular educational institutions recognized by the state primary and high school, and intermediate boards. And therefore, the educations being imparted in madrasas is neither quality nor universal in nature.
So
This is the heart of the
court
act.
is comparing the students of madrasa with other students,
My lords,
and it's trying to convey that this is violative of Article 21 capital A,
my lord.
para 84.
Yes, my lords. While the students of all other religions are getting educated in all modern subjects, denial of the same quality by the Madrasa Board amounts to violation of both 21A as well as 21 of the Constitution. The state cannot hide behind the lame excuse that it is fulfilling its duty by providing traditional education on nominal fee. The Supreme Court has repeatedly emphasized on modern education with modern subjects, an education that is universal in nature, that prepares a child to make his future bright and to take this country forward. It does not prescribe by any stretch of imagination limited education with emphasis only upon a particular religion, its instructions and philosophies. Education being provided by the Madrasa Board therefore is in violation of the standards prescribed by the Supreme Court while interpreting constitutional provisions. Therefore, this court has no hesitation in holding that the education being provided under the Madrasa Act is violative of Article 21 and 21A of the Constitution of India. So your lordships will see, my lords, even in page 84, in paragraph 84 and in the paragraphs above, the equivalence is made wrongly, my lords, respectfully by the High Court, between madrasas imparting religious instructions and therefore violating secularism.
Now, that's the second aspect. Now, third aspect is a conflict with the UGC Act, the High Court has dealt with.
Yes, my lords.
So, what is that finding?
Yes, my lords. My lords, the
Right,
finding.
85 and 86.
Yes. So, my lord, this portion of it starts at page 74, bottom of the, page 81, bottom of the page. And the findings.
Do the madrasas trench into any area which is reserved for the UGC under the UGC Act?
No, my lords. My lords, the conclusion of this. Where is the conclusion? Paragraph 99, my lords. The conclusion. And this is at page 92. Conclusions are at the bottom of the page, my lords.
So these madrasas are up to which standard?
Plus 12.
Plus 12, my lords. It's 1 to 12.
UGC talks about right to confer degrees. So what role UGC has to play up to 12th standard?
May I just take instructions?
Does High Court say there is a conflict between the Act and the UGC regulations?
Para 96 might help.
96 and 97, what they say is
That's right.
that section 9A of the Madrasa Act confers power in the board to prescribe courses of instruction,
Granted.
textbooks, other books and instruction material, even for Alim, which is the undergraduate course,
Yes, my lord.
Amil, that is postgraduate course, Fazil, that is junior research programs and other courses.
That's right.
So obviously, the Madrasa Act is made in pursuance of the power conferred by entry 25 of list 3.
Yes, my lords.
That is subject to entry 66 of list 1.
That's right, my lord.
Because that part, which was really subsumed in the UGC Act, would therefore stand excluded from the Madrasa.
That's right. But my instructions are that we have applied for this recognition. We have applied for recognition post class 12, my lords. We have applied for recognition post class 12. So at this point, we don't run post class.
Assumption that if some student after 12th class wants to pursue higher education within the madrasa, then the higher education is within the domain of the central government. There is already UGC Act. So you need to have affiliation for that, and that's not there.
Integrated provisions, 9C.
My lords, this only.
They went provision by provision.
They are just breaking this down provision by provision and therefore saying that the provision is unconstitutional. There is no factual material before the High Court at this point. And Mr. Khurshid, I think will address your lordships on this portion, on the UGC part, my lords.
The certificates.
We have been applying before this.
Come back to section 9A
Yes.
at volume 4A, page 37. Right? Now, 9A says
Yes.
to prescribe courses for instructions, textbooks, and other books, and instructional material, if any, for Taitanya,
Yes.
Fokania, Munshi, Maulvi. Now they say Alim is undergraduate. Kamil is postgraduate, I think. Jamshid,
That's right, my lord.
Yes.
right? The High Court says Alim is graduate, Kamil is postgraduate, Fazil is junior research fellow. Now, anything which falls within the purview of the UGC Act would therefore, the Madrasa Act would be subservient to that,
My lord.
unless it receives presidential assent.
And this is what we have applied for. We have not.
No, but therefore, one thing is very clear, that unless there is either the UGC grants affiliation to those institutions or they comply with UGC regulations, no educational institution can confer any degree or carry out any course of instruction which is in conflict with the UGC Act. The UGC Act, in Professor Yashpal's judgment, says no institution can confer a degree
Yes. And
unless you are affiliated as a university, unless it's a statutory university or affiliated as a
don't
team.
confer a degree, my lords. We are conferring only certificates. And may I just show you where we apply for permission? Until we get that permission, we will not be conferring any degrees of any sort. Please see page 847, my lords. Volume 3A. This answers your lordship's question. This is what we have done on this portion.
Higher education.
On the higher education portion, which the High Court, my lords, respectfully is only extracting the statutory provisions. Yes. So volume 3A,
847.
page 847.
That is about considering the pay scales of teachers.
My lords, no, my lords, this is